Our last speaker before the breakouts is John Romeo of Gibbons in Philadelphia, where he heads the firm's employment and labor practice. John is a former in-house lawyer. Prior to joining Gibbons, John was the labor and employment counsel and chief ethics and compliance officer for American Waterworks Company. Throughout his career, John has represented both private and public employers in all aspects of federal and state labor and employment law. He has assisted employers in developing, drafting, and implementing employment policies, compliance and ethics programs, drug-free workplace programs, and executive employment agreements. Today, John will be speaking on conducting effective workplace investigations. And they're making me say that standing between you and lunch, here is John Romeo.
Thank you. Well, before I joined a network firm, I was in-house, and I had the opportunity at one of the network events to have lunch with Ellis. And I realized that's why he put me right before lunch, because he knew there was no way I wasn't going to be there at 1 o'clock for lunch. So I think it was a good choice. Both in private practice and when I was in-house as a chief compliance officer, I had an opportunity to conduct literally hundreds of investigations and oversee probably hundreds more of HR staff or audit staff that did the investigations. And there's a lot of good reasons to make sure you do it right. Culture in the company, following policies, avoiding theft and limiting risk. But for me personally, I want to make sure every investigation I'm involved with is ultimately upheld and supports the company's decision that they make as a result of it. Green book. So one of the most difficult investigations I was ever involved with, it was very tense and challenged. It involved an entire workplace and resulted in the termination of perhaps as many as 20 different employees from one workplace. As a result of that, 12 employees brought charges as a result of their termination, and there was one arbitration with a three-arbitrator panel that handled it. I personally sat on the witness stand for 2 days to defend my investigation and got cross-examined by multiple lawyers. It was very, very difficult. Ultimately, this is what the arbitrators found. The hearing showed that the company conducted a fair and thorough investigation, that the investigator was professional and objective. And I realized that's what we're going for, because after that, the investigation's upheld, all determinations are upheld, and everything moves forward. That's what we're going for as lawyers. We want to have an arbitrator say, or a judge, or a jury, this was a well-done investigation, and we're going to uphold the decisions that followed therefrom. So what I want to talk about is some of the mistakes people make. This isn't brain surgery. A lot of this might not be new, but I see these same mistakes over and over and over again. So I've narrowed it down to maybe 8 or 9 mistakes that people make that are going to be a problem in their investigation. Before you get there, the first mistake that's made, something to talk about all your clients with, is not training supervisors and managers what to do when they get a complaint. So many supervisors and managers, they have a job to do, right? Their job is to meet a certain goal or get a certain amount of production out or do something in particular. Their job isn't to deal with all these issues that come up. And I've seen supervisor after supervisor just try to resolve an issue. Go apologize, go work in a different part of the plant. They just want to resolve it and move forward. They're not equipped to handle investigations or complaints that come up. So what I want to tell my investigators, my supervisors and managers, is how to receive a complaint. Don't necessarily agree with the person when they complain, just listen. And then how to get the complaint into the hands of the people that are equipped to deal with the complaint. Don't try to resolve it yourself. That's not your job. You have a job. We'll have somebody else do the investigation. And they're really in a tough position because these things come up all the time. How do you handle it? I'm just venting. I'm just getting off my chest. I don't want you to do anything. I don't want anybody to get in trouble. And supervisors are like, okay, I heard you. You vented. Go back to work and do nothing. Well, that's not acceptable. Supervisors need to be trained that is a complaint, and action needs to follow from that. And it happens all the time. It can happen at dinner. It can happen at a holiday party. It can happen at a bar after work. If an employee complains to that supervisor, they need to be trained on what to do. Once the complaint comes in, what do? I always tell people, read the last chapter first. Go to that deposition. Go to that trial. What questions are you going to be asked? Make sure that you're conducting an investigation, that when you're cross-examined or when you're asked questions about it, you're going to be able to say why I did what I did. This is why we did it, this is what we did, and this is why it made sense. Don't get, caught off guard doing a quick investigation or not really having an outline or a plan, and then you can't defend it down the road. So right up front, define the scope of your investigation, set out your objectives, and importantly, consider whether there's any need for interim measures. Any actions you need to take now. Do we need to separate people? Do we need to suspend somebody? Do we need to give somebody a leave of absence? What can we do to make sure anything that has been alleged stops now while we do the investigation? People ask me all the time, do you suspend people with pay or without pay? I guess it goes both ways. You know, I'm from Boston originally. Aaron Hernandez, he gets suspended without pay. We never see him again. That's a good thing. But most times, I say suspend with pay. The reason for that is I want to maintain objectivity. And I think as soon as you suspend somebody without pay, you're sending a message that you already think that person's guilty. They've already done something wrong. And I like to avoid that. And for the cost of a week or 2 weeks' pay, suspend them with pay, and then cross that bridge down the road once you complete your investigation. The next one is very simple, failing to conduct the investigation quickly, timely. There's really no excuse for it. It has several downside effects from an HR perspective. You know, it calls into question the integrity of your investigation, the sincerity of the employer with respect to its rules and policies. And importantly, it really can impact the affirmative defenses that an employer has for conducting an investigation. So the courts have said, you didn't do this fast enough, and therefore you can't say, we did everything you could ask us to do to defend ourselves in this, say, sexual harassment case. So just not being timely alone can call into question the credibility of your investigation. And that's, it's an easy one to make a mistake with because everybody's got so many things on their plate, but it's really a difficult one to deal with if you didn't do something timely. If you have a complaint and you investigated it 40, 50, 60 days later, that's not going to be an easy sell. And there's a lot of decisions that come into that. You don't just have to investigate quickly. You know, there's questions about, do we investigate? Should we investigate? Is an investigation necessary? I kind of limit that to 2 questions. Is there a violation of law or policy? And do we already know all the facts? Are there any facts in dispute? If there's no violation of law or policy, if we already know all the facts, we don't need to go through a whole investigation. You got to make that decision right up front, though, and where to go from there. If you're not going to investigate, just document why. This is what we learned. You know, this person came in and complained. The next day, the other person came in and admitted to doing everything. We took note of that. We didn't have to investigate. Or there was no violation of policy, and we communicated that back to the person that complained in the first place. But document it so you just don't have no records or no file on the complaint that came in. This one seems simple as well, failing to select a proper investigator. As lawyers, a lot of times we're either going to investigate or we're going to oversee an investigation. We might want to direct it, try to maintain some privilege issues. I always assume every investigation ultimately will not be privileged because that way, if in all likelihood it comes out and is public, you haven't said anything that's going to harm your client. So I always assume it's not going to be privileged, but there are steps you can take to try to make it privileged. But you need to, so if you're going to have a lawyer investigate and you're trying to maintain that privilege, you need to decide that now and quickly and move in that direction. If not, you need to make sure the person you have investigate is trained and not biased, okay, and they have some experience. And when I say biased, I'm not just talking about objectively from the perspective of you as the lawyer or whether you're doing the investigation or overseeing somebody else. Biased from the perspective of the witnesses, the complainant, the alleged wrongdoer. Are they going to think there's a bias? Because if somebody is presumed or perceived to be biased, even if they're not and they conduct a great investigation, down the road when they're getting cross-examined, they're going to look biased and it's going to call into question the entire investigation, even if everything else they did was by the book. So I think it's important to try to avoid that. And it can come in many fronts. I mean, one of the problems people face is you might have a small facility somewhere outside of where your main office is. You have one HR person there. That person does the investigations. Well, if that happens, and the person they're investigating is someone they hired, had dinner with 3 nights ago, and had their family over for a swim party, it's not going to look good. So you need to be careful not to just say this is the person that investigates at this location, because it can really come back to haunt you. A sham investigation or just going through the motions. This is probably the biggest mistake that I see people make in investigations. Comes a lot when in-house people, whether they be HR staff or lawyers, are doing the investigation. and it's a result of being too intimate or having too much knowledge about the company that they work for. So really it comes up in two different ways. Number one is kind of the gotcha CSI mentality. I develop right away as soon as I see a complaint what happened. I put blinders on, and I'm going to prove my theory of the case. I'm going to go out and prove it. I'm not just out looking for facts. I'm not just gathering information to make a decision. I'm going to prove my theory is right. And that's problematic. You need to avoid that. But worse than that is the investigator that says, this person's full of it. This lady's crazy. She brings a complaint every month. Or I hear this all the time, the only reason they complained was because they got a bad review. And I step back and I say, so this employee complained of, say, race discrimination or sexual harassment. You're telling me it's not valid because they got a bad review. I don't care about the bad review. If that's what made the person bring the complaint, so be it. I want to find out if the complaint's valid or not. You can't just dismiss the complaint because you think that there was another motive for bringing the complaint. If, in fact, the person brought a false complaint, you can address that later. But investigate it like you would any other complaint. There's no reason for not reviewing all the relevant documents before the complaint. We're all trial attorneys here, right? We wouldn't go into a deposition blind. You don't want to go into an investigation blind. There's a lot of evidence and information at your fingertips, whether it be, time cards or when someone swipes in and out of the building or emails or text messages. I can't tell you how many times I've sat in an investigation, reached across the table and asked somebody to give me their company-provided cell phone. And faces drop. Because you're going to get their text, you're going to get everything they did. It's all on a company-provided phone. Avoid the personal stuff if you can, but anything that's business-related you can get. And you need to get all that information early in the process. It'll help you develop your investigation, much like it would for the deposition, really not much different at all. One of the things we like to get when we do investigations now is social media, which is kind of a hot topic in this area of the law. Number one, I say get it. You got to complain about somebody, go on their public pages, go on their Facebook page. I go and get it and see if I can find anything relevant to the investigation. But that's where I stop. There's kind of this need or desire to get more information. Some employers will try to be sneaky and backdoor their way into a private Facebook page by pretending to be someone that they're not. That's obviously a problem. I don't need to say that. But other employers will just be more forthright. We want your password to your Facebook account so we can see what's on there. That's really problematic. There's a trend. A lot of states are putting laws in that prevent that and preclude it. There's a lot of legislation against that, even requesting that information. If you want to do it, you really want to do it, just check with your local lawyers from that state. There's lawyers in here from almost every state in the country. Check with the lawyers from that state and find out what the status of the law is in that state before you go and do that. Another consideration with that is with respect to the NLRB, the National Labor Relations Board has been really over the top on how they handle social media information. So an employee can go on their Facebook page and say, my boss is the biggest stupid ass I've ever met. I hate him. I don't want to work for him anymore. And, you come to work and, the boss gets confronted with this. She's not going to be real happy about it. And a couple other co-employees might throw a thumb up on it on Facebook, and it's a problem. So, I was in-house. I had that boss come into my office. I want him fired. I want him fired now. Seems reasonable. The National Labor Relations Board makes it really clear that you can't fire somebody for that. If they are engaging in what they call their Section 7 rights, they're seeking the mutual aid of their co-employees to deal with the terms and conditions of their employment. And those employees that say those things often get put back to work with full back pay, and you have a really mad manager walking around. So I would say, if you're going to take action based on someone's Facebook page, be real careful. We did it once. It was really easy. Employee took a day off for sick leave and posted on his Facebook page, which had no less than 50 of his co-workers and supervisors on it. He's sitting at the Steelers game, and they're getting their asses kicked, and he posts, I can't believe I took a sick day for this. So probably not the smartest thing he ever did. It didn't matter how many thumbs up he got for that. Similarly is speak to the relevant witnesses. This kind of follows the sham investigation. You think you know what happened. You talk to one or two people. You document it. You make a conclusion. It's really not a good way to go about it. Speak to everybody that's relevant. You don't need to pile on. If somebody's not going to provide new information or different information, then document. I'm not talking to this person for this reason. But speak to everybody that's relevant. The complainant's going to give you the names of people. Other witnesses will give you the names of people. Speak to them. It's very important to document, to speak with them and to document that you did speak with them. When you're talking to witnesses, this question comes up all the time. What if somebody wants to bring somebody with them? They want to bring a lawyer with them to sit during the interview. And almost 100% when I talk to investigators, they say, we don't allow that. We don't allow them to bring a lawyer with them. We don't allow anybody there. I disagree. I come back to one question. Is this going to help me gather facts for my investigation? Is it going to help me gather facts for my investigation? I'm not going to just carte blanche say no lawyers in the room. Handle it. Deal with the lawyer in the room. Send him to a corner, tell him to be quiet and listen and take notes if he wants. And have him have the same confidentiality charge that you give the witness. But by saying no, leave, what you're saying is I'm not going to gather the information that this witness that I thought was important enough to talk to was going to provide me. Don't do it. You're cutting off your nose to spite your face. Deal with the lawyer. Take action with the witness. Now, there are some exceptions if the lawyer becomes a problem. If they're starting to instruct their person not to answer a question, you might want to have a conversation with the lawyer or end it or move in a different direction or just document that that's what the lawyer did and that's what they said. It's not the end of the world. Secondarily, if somebody wants to bring somebody in that might end up being a witness, you don't want to have them in there with that person and then coming back later as a witness. And just keep in mind that there's some union considerations. If you are interviewing a witness who's in a union and there's any possibility for discipline for that witness, they have the right to bring in somebody with them, usually their union steward or somebody, into the interview with them. If you decline that, then that's a violation of the National Labor Relations Act. Real quick, when I speak to witnesses, I always give them the same warning up front. I introduce myself and I tell them I'm an attorney, so there's no confusion there. I talk to them about confidentiality. It's twofold. I tell them to keep it confidential. I tell them I'll keep it as confidential as I can. We never promise or guarantee confidentiality. Talk to them about retaliation. They shouldn't retaliate against anybody, nor should they be retaliated against. I talked to them about document retention. Save all your documents. I had a guy once, we had someone selling drugs at a workplace, and we told him, don't destroy any documents, don't destroy any records. And I had an assistant with me who had live access to the guy's email. He left the interview. 5 minutes later, we're interviewing the next person, and she's watching him delete every email in his inbox as it's going through. So we called him back in, and he said we had gotten an email from IT. It was time to purge old emails from the email list. So it really didn't fly. This is a to each your own. A lot of lawyers will have a form. They will read the form. They'll put you under that spotlight about all of these warnings, and then you have to sign it and hand it back. It's okay. I think it sets a bad setting. Somebody they got drawn back and they're afraid to talk at that point. I usually just have that conversation with people and then document that I had the conversation. Maybe have them sign off on it at the end. But I don't like to set a bad tone right up front. Documenting the investigation is probably the most important part of the investigation. You want to have contemporaneous notes. There's nothing better down the road at a trial or at an arbitration than contemporaneous notes that document your interviews. Very important to have it right. I like to let the witness see it and sign off on it. This is accurate. This is what I said. It's very important. And maintain confidentiality with it. You shouldn't be something that you're going to be talking about at lunch or handing over to other people or showing to anybody in the company. The person that should see your notes and your documents are the people that are directly involved in the decision making. I'm going to move on to number 9, which is maintaining confidentiality, because the National Labor Relations Board strikes again. We always tell people to maintain confidentiality. It comes in a lot of fronts. I had one investigation done by a lawyer who had their assistant walking through the offices, going to the administrative assistants of the people that were allegedly the wrongdoers, asking for the documents relevant to the investigation right there in the middle of the workday. Then nobody did any work for 2 weeks after that while all the scuttlebutt occurred. So there's a lot of ways to maintain confidentiality, and that's one of them. But a blanket prohibition, do not discuss this with anybody. To every witness you talk to, the NLRB says no, you can't say that. They say that's taking away their right to talk to others about terms and conditions of employment. There are four exceptions to that. 1, if it's to protect a witness. 2, to avoid destruction of evidence. 3, if there's a danger of fabricated testimony or to prevent a cover-up. Let me tell you what I do. Every witness I talk to, I say, don't talk to anybody about this case. Don't talk to anything about anything we talk about. And then in my notes, I document one of those reasons why. Find one. And at the end of the day, I'd rather keep confidentiality than worry about what the NLRB is going to say about it. And then lastly, take proper corrective action. It can come in a lot of forms. Training, warning, discipline. but take it. It really comes down to two things. It needs to be prompt, and it needs to be aimed at stopping the conduct. I always tell people there's a difference between a wrong decision and a bad decision. A bad decision, you didn't consider the facts, you didn't consider the information, you made a decision, it was a bad decision. A wrong decision, if something turns out to be questioned, at least you can say, I considered all the facts, I considered all the information available to me, I made a decision. I would submit in the Rutgers case. Seems like a bad decision. They kept that basketball coach on board after he was kicking people and throwing balls in their faces. But you know what? He did the investigation, he viewed the videos, he talked to the right people. I think he made a wrong decision. He considered all the facts and made a decision. Every time you make a decision, make it based on the facts that you learned during the investigation and document why, and try to avoid drawing legal conclusions. You know, this person violated this policy, fine, not this person illegally discriminated against this person. I would try to avoid that in my notes and in my documentation when taking corrective action. And that's all. Thank you.